Now, Mr. Robinson, you're going to make submissions to me on behalf of the Belfast Health and Social Care Trust and Health and Social Care Board.
Yes, I'm obliged, Sir Brian. May I firstly, on behalf of the Northern Irish Bar, welcome you to Belfast.
Thank you. I was once a member of the Northern Irish Bar.
Well, I didn't check that as a technical point, but I'll take your word for it,
thank
Sir
you for
Brian.
welcoming me back.
Yes, I welcome you back, Sir Brian. I'm obliged. Sir Brian, no submissions can move forward without first acknowledging the bravery of the witnesses that have appeared before your inquiry. The manner in which they have opened their lives in this public forum is deeply moving, and no doubt based on a pursuit of the truth about what happened. Now, when we look at what the final object of this inquiry is, that object is a report that is the truth, that it's accurate, and that it is unimpeachable. And one of the ways to ensure that is to put the best evidence before the inquiry. And the best evidence in our respectful submission is based on fundamental fairness to all who are touched by the issues. That fairness arises from the equality of opportunity to present their stories, and also the equality of voice, the equality of being heard in the same way as everyone else. I'm reminded of the words from Mr. McGuinness, who appeared at the opening on behalf of these bodies. And he said that the infected and affected were entitled to the truth, and the truth as soon as possible. And that the bodies that he represented and I represent give an assurance of full cooperation to your task. And that has been demonstrated in our submission by the responses to Rule 9 requests to date regarding document retention and policies, but also the sending to your inquiry thousands of pages of documents. And that, in our view, demonstrates our willingness to cooperate with the inquiry. I want to say that that cooperation is unwavering and will never waver. It gives me no pleasure, Sir Brian, to raise matters of procedure that cause my clients some significant concern. These concerns are expressed purely in the spirit of collaboration. They are not criticisms or attacks. These are, for want of a better word, the airing of difficulties we've experienced in assisting the inquiry.
Well, they must be criticisms if you want to change, because presumably you want to change for good reason. And if there is good reason, there'll be a change.
Well,
but they are criticisms.
A suggestion that prompts change is not necessarily a criticism. We are trying to cooperate, and we're trying to highlight how things may work better to assist you getting to the truth. And one of those issues is, some of those issues arise from dealing with individual doctors and the isolation of doctors who have been asked to respond to Rule 9 requests. If I take, for example, Dr. Main, I act on behalf of Dr. Main, and we received 10 statements containing criticisms on the 29th of April, a little over 3 weeks ago. She was told she could not speak to the trust, and as her lawyers, we, who also represent the trust, we could not speak to the trust about the criticisms. Now, throws up a number of issues, and one is the support aspect to current and former employees. Doctors employed by the Trust are providing care on behalf of the Trust. They're emanations of the Trust. And we say a criticism of the individual is a criticism of the Trust. They are its servants and or agents.
So you're basing the Trust's involvement on the employment status of the doctor?
If a patient was injured in surgery and they commenced legal proceedings, they would sue the Trust. If they had a complaint and they take it to the Trust, it's the Trust that deals with it. The separation of the individual doctor from the Trust, in our respectful submission and in our experience, has caused significant difficulty, and it is an impediment in getting to the best evidence from that witness. And that's exemplified because with Dr. Main, this is a witness in her 80s. She retired 20 years ago, and because she couldn't go to the Trust, she compiled the statement from her memory. Now that, in our respectful submission, weakens the best evidence that can reach this panel. If she had the time and opportunity to liaise with the Trust, first of all, to gain support, because being professionally criticised in such a public forum causes shock and distress. And for that witness, and for any witness, we say, to properly give the best evidence, they must have not only sufficient notice, but also sufficient time to review documents. If it hadn't been for Dr. Main's desire to assist the inquiry and have something before the inquiry, and the assistance of one of my solicitors, Lisa Donachie, if it hadn't been for their work, the statement wouldn't be before the inquiry this week. And that, in my respectful submission, impedes the inquiry's task, because to get to that final report that is unimpeachable, the route there must be clear and unimpeachable. The witnesses must be fully equipped with all the relevant information so they can assist you and give the proper answers. For example, Dr. Main replied to the 10 critical statements without any other assistance and reliance on memories going back into the 70s, 80s and 90s. Now, in any other forum, a witness subject to criticism would be entitled to have full examination of the notes and records and time to consider those. There may have been a note about a conversation or further correspondence that can put matters into context. And I believe that's demonstrated when we have witnesses that we've heard from today that say, I only learned that an hour ago before I give evidence. Or with the second witness, Bridget, when she learned of the context of the letter sent by Dr. Main. We say the fact that Dr. Main has been able to present the context can only be a step forward and can only be the best thing, not only for the inquiry, but for the infected and affected. And it takes me to it's the end of paragraph 4.2 of Dr. Main's statement. Now, the end of that, this touches upon the meeting that Dr. Main had with Bridget's father. And the very last sentence states, I suspect he never told anyone of the visit, which is a shame, as it might have saved the agony and anxiety of his family. So, the more information and the more context the inquiry has, the better equipped the infected and affected witnesses are when they come to give evidence. If they knew of the doctor's response well in advance of sitting in that chair, they give the best evidence they can, because they will have a time to digest what the doctor is saying, process that, and then in a relaxed fashion give evidence about that. And I say, and we say, that that can only assist the inquiry moving forward. The Trust have been told, through the statements that have been provided, the Trust became aware of other clinicians that have been criticised. We sought permission to contact those witnesses, again in order to assist in supporting the witness and also providing them with any documentation or advice that they may require. And this follows from a recent inquiry in this jurisdiction, the hyponatremia inquiry, in which there was criticism of the Trust for not contacting doctors against whom criticism had been made. So the Trust are in a position where they're trying to assist. They've been criticised for not contacting doctors in the past and are prevented from doing so in these circumstances. It also has placed the lawyers involved in an invidious position because they have knowledge of other clinicians being criticised but can't speak to the Trust about that, and there's no way to contact the doctors about that. And that causes a problem because when looking at the context, we had those statements from the 29th of April. It's obviously a lost opportunity that we weren't able to contact the doctors immediately and put in train a process to try and obtain responses before today. There's also a contextual point that when one looks at the statements that we received on the 29th of April, some date back to January of this year. And we say, if the Trust had notice and was able to contact these doctors, it would have assisted the inquiry and the infected and affected. In the absence of those restrictions, we could have hopefully engaged with those practitioners to help the inquiry have the context and relevant evidence relating to all the allegations, so that this session would have been the airing of the allegations, the doctor's response, and comment from the infected and affected witness. And all we can do is, we wrote, we've spoken to your team to highlight these issues. And I must say, I'm not criticising your team whatsoever. They are a formidable team. They've been working incredibly hard, and given the volume of documents and the issues in this case, they have my respect, I must say that. But what I'm trying to do is remove any impediments to assist you. And I think that has always been the approach of my clients and will continue to be that approach. Now, going back to the point about fairness, fairness implies balance, and it implies an equal opportunity for every witness. We have a system where the witness has had the time to consider the Rule 9 statement, has time to put notes and records attached to it before they give evidence, the time to think about the ramifications of what they say and back it up with any further information. They are placed front and centre in front of the public. Their testimony is broadcast, it's recorded, and no doubt reported, and rightly so. And I make no points about that. But there's an imbalance in the system because we have the medical professionals who have built up careers, their reputations, and their patient confidence can all be gone in a matter of headlines. Their self-confidence, their the confidence of their patients in the care that they're providing can be damaged significantly by criticisms that are aired without any context and without a proper response. The only route that a doctor has after being criticised is to file a statement, and that statement is posted online. But for the work of the DLS, when they've been contacted by doctors, once that contact has been made, great effort has been put into replying to the criticisms. So at least for this week, there are responses from some of the doctors, not all of them, but some of them. If that work hadn't been undertaken, the moment would have passed, and all the doctor has is a statement posted online, and no opportunity, as far as have been made aware of, no opportunity to come along to you, sir, and say, look, I can give context to that, or there's a note in the records, there's a set of letters, there is a diary entry I made about this, so that it's set, so the full picture is presented to you. What I would respectfully submit is that is the only way to ensure that there's fairness inbuilt into this system, rather than the frightful position where a professional is mentioned in the news, tweeted about, discussed, but by the time that medical professional has an opportunity to respond, that allegation is out there, and there's very little that can be done to pull it back. And in this age of instant news, instant social media, and the rate at which the news cycle changes, the moment for that doctor to provide the context is gone. And essentially that doctor has no voice before the inquiry. Now, I did provide a skeleton, which just touched upon some points. How is this best managed? There are various options. One is that the criticisms are essentially parked until the doctors provide a response. And then at that stage, they're aired with a proper response and oral evidence from the doctor. If it is the case that these criticisms are not going to form part of your report and are not going to be dealt with, well then one approach would be to say, well, look, if that's a complaint against the doctor, unless it's the systemic issue that I'm dealing with as part of the inquiry, that should go to a complaints body or some other vehicle to have that aired and dealt with appropriately. In correspondence to the inquiry, sir, we sought the abandonment of this separation of trust and doctor for the reasons I've indicated. We also sought to contact individual doctors that we saw were criticised within the papers.
Well, the reason you've given me so far for reading the trust and the doctor as one is that if there are civil proceedings against a doctor, the trust would be liable. And the reason for that is that the trust employs the doctor. Have I understood it?
The doctors are emanations of the trust. The trust...
Well, let me ask you this. Yeah. Is a nurse an emanation of the trust?
Yes.
So let us suppose that a nurse takes unlawfully from a cupboard beside a patient's bed some property belonging to the patient. It happens.
Yes.
Is the nurse then acting as an emanation of the trust?
Well, that's a criminal offence, and that's a separate act.
The question is a simple one.
If in a civil action, no doubt the plaintiff would sue both the nurse and the trust, because the patient is providing or is trusting the trust organisation to look after those belongings. So I would, if I was that patient, I would issue against both, because that the duty of care is owed from the trust to the patient to ensure not only safety in relation to care, but also to their belongings. Practically speaking, there would be no value in targeting the nurse.
Well, does it, or does it, is it not perhaps that the trust owes a duty to take reasonable care? That is, in organising the systems that it has, in seeking to employ, so far as it can tell, safe and competent employees, and laying down safe systems of work, the traditional analysis of liability for accidents at work. If that's the trust's liability, the individual person who is at fault, a nurse acting entirely outside what one would expect a nurse to do, let us suppose, they would be liable. If they are negligent and careless in doing what they are supposed to do, but just doing it carelessly, they are liable. The trust is liable too, but it's liable because it's got deeper pockets and because that's the principle of vicarious liability. Have I not understood it rightly?
You have indeed, Sir Brian, but that's that fine slicing between particular acts of the individual and whether it takes them outside the protection of vicarious liability. That's a matter for, that's not what we're talking about here. We're talking about doctors that are being accused or accusations are being made against them in the normal course of the provision of care. For example, Mr. Kirkpatrick, the very first witness, made comment about, give evidence about how a doctor provided advices or didn't provide advice regarding trying to conceive a baby whilst on treatment. Now,
that was echoed by the last witness in
yes,
her own experience.
Yes, and the very last part of the paragraph in that statement from the first witness said that was the point that they started to lose faith in the trust in the hospital. Now, in those examples and the examples that I've read from the papers, they're all examples of where a doctor is acting in the discharge of their duties as a doctor on behalf of the trust. And in my respectful submission, that's covered. That's covered by vicarious liability, it's covered by the duty of care, and it's covered by the fact that these are emanations of the trust. If, apart from this inquiry, if this inquiry didn't exist, and Mr. Kirkpatrick took issue with how he was treated, he wouldn't simply sue. He would go to the trust to complain about the care that's being provided, and if there was a breach of that duty of care and issue proceedings, he would not appear on the proceedings, it would be the trust. So we say, from our examination of the criticisms, nothing takes the individual doctor out with the protection and the scope of the liability and responsibility of the trust. And it's also of great concern to the trust if there is an allegation of a lack of care, that they want to know so they can fix it or investigate it or stop it happening again. So it's not simply about the one-off incident contained within a statement. It's whether or not that a doctor did the same thing in other cases or if there are other complaints. And it's about the concern of the trust to protect the public confidence in the care that is provided. So we say that all of the complaints that have been put forward are covered by that vicarious liability or that extension or emanation of the trust. And Sir Brian, these submissions are not made to cause difficulty. They're made to try and remove an obstacle to help the inquiry. Because if those obstacles have been removed, and we had noticed back January, February, March, and I know there is an evaluative process on what statements are taken forward, and I accept that. But if we had had prior notice and we were able, even from the 29th of April, to reach out to these individuals, we may have been in a position to have had statements before the inquiry. So we can explore the responsibility between individual doctors and the trusts, but looking at what we have been provided with, nothing removes that individual from the protection of the trust. We also have asked for notice of any further criticisms so that responses can be provided, wholesome and fulsome responses can be provided to you as soon as possible. I've covered in the submission, I've mentioned some points about communication between the trust and your team. In the spirit of collaboration, I do not intend to elaborate upon them. I'm looking forward to working with your team on all levels and as much as we possibly can. I don't believe there's anything at this stage to be gained by exploring that. What I am trying to do and what my clients are trying to do is make sure that at the end of this process, when the report is produced, that it is a report that is truthful, it is accurate, and it's unimpeachable, because everyone that has an interest in this in these matters has had their voice heard on equal terms. The reason, again, I'll reiterate again, if we move forward like this, we can help the infected and affected give the best evidence they can give, and that you also have the best evidence so that you're ready when you write your report with everything done properly, and you've been given the full assistance that can be given, unless there's anything further.
Well, yes, there is. You've said that one option is, and you gave, I think, an example which perhaps is more clearly set out in your skeleton. One way of solving what you call the obstacle is to only air the criticisms when the medical professionals are able to provide a full response and appear to respond orally to the allegations. So that would involve redacting the paragraphs that contain the criticisms until such time as a full response is received. Then you say the witness can be recalled, the allegation aired, and the response put to the witness, followed by the medical professional providing evidence.
Yes.
Now that's one option. What are the others?
The reason I mentioned a recall in that part of the argument was because we're at the start of the oral hearings. So if the criticisms are to be maintained, they can be redacted, and when the doctors have the opportunity to respond, we reconvene. In the circumstances where no oral hearings have taken place, there would be no reason to recall, and hopefully the timetabling of disclosure and response takes place to enable the oral hearings to consist of the infected and affected witness giving their evidence, commenting on the response from the doctor, and the doctor providing an oral response at that hearing. That's one way to do it. And in fact, that then enables the witnesses to air what they wish to air before the inquiry.
So if let us suppose we have Dr. Main, and if, let us suppose, we have 10 or more witness statements which have some developed criticisms of Dr. Main, or they describe events which could be seen as criticisms of her, what we would have is the witness called, give the evidence, Dr. Main would be there to answer that, then the next witness would come along, give evidence, Dr. Main would be there to answer that in turn?
Yes.
So this would mean Dr. Main would be coming on 10 occasions? or more?
No, well, no. If it should be coming on one occasion to answer the allegations.
One
Make
to
appearance.
answer all 10?
One, same way, if she was here today to prove her witness statement, she would come in and give evidence. Or after the individuals have given their evidence, she comes in at the end to answer those allegations.
But if you have, let us say, 10 witnesses, each of whom has a criticism against the same doctor, how is it to be handled without the doctor coming along to give evidence at some stage? And your proposal, as I understand it, is the doctor would come along after each individual had given their criticism. And one can understand the criticism is made, it's made live streamed, the world can see it, and it is there immediately rebuffed or answered or endorsed or accepted by the doctor. But that would happen, would it, on each occasion that there was such a criticism by a witness? Wouldn't it have to?
Well, if we take Dr. Main as an example, and we hear from the infected and affected over the course of a week, those 10 witnesses. Prior to that taking place, Dr. Main's response will have been provided to those witnesses. So when they're giving their response throughout that week, and it's put to them through your counsel, and they respond to what Dr. Main has said, then Dr. Main gives evidence at the end of the week to adopt her statement as her evidence, and then expand if required.
So what we're talking about is a question of timing and convenience. Is it a mixture of the two?
Well, I think structuring, Sir Brian, if we are structuring this, the best evidence from the infected and affected witness is when they have the doctor's response and they have time to consider it, and then they take the stand and they give evidence and they comment upon that. So we need to look at, I suggest we look at timetabling that in advance so that the witness is in the box and is fully equipped with all of the evidence that they wish to put forward and the evidence from the doctor that they've criticised. And that may clarify points, it may provide context, whatever, but it's going to be the best evidence. And at the end of that process, and they take a seat, and Dr. Main gives evidence, and she will explain her perspective, adopt her evidence, and be questioned about her statement. So I wouldn't say it's about convenience. In my view, it is about trying to balance the timing of disclosure to ensure that everyone, by the time they sit in this box, is ready and has everything before them. It's simply to make sure that whenever the witness leaves the box, there's nothing left hanging, or there isn't an allegation out there that has been unanswered. They hopefully add to some closure and some clarification. And that's, I'm not making these points in contest, I'm making these points as suggestions, as invitations to consider how we assist you in your task. Once that witness finishes giving evidence, the doctor will then give evidence and, as I said, adopt their statement and answer questions from your counsel. And that should end that process.
Yeah. The overall principles which apply, so far as fairness is concerned, the principles of natural justice and Article 6 would apply, would they?
Well, I didn't include any authorities in my skeleton. I thought to set out authorities to you, Sir Brian, would be suggested patronisation, and I wouldn't even dream of that. I don't need to tell you, Sir Brian, what fairness is. The application of Article 6 depends very much, for public inquiries, it moves with what the terms of reference are. And the more a subject or issue is closer to the terms of reference, the more one can argue that the right to respond arises. Now, in my respectful submission, what we have here is an opportunity to dispel any imbalance or unfairness by affording the doctors the chance to have their say.
Well, I think it's more than that, isn't it? As I've understood your submissions, first of all, there has to be a chance, a reasonable opportunity to put their side of the case if they are criticised.
Yes.
Because that seems to me to be part of the aspects of natural justice. It's the right to have an opportunity to put your point of view.
Yes.
But the real question is, as I understand you're raising, is when.
Well, when and how, because...
Well, how it becomes a matter of process once the when is decided upon. But your argument for when is largely a practical one, as I understand it, which arises on the basis that it may be that criticisms which are made and are not answered or dealt with or responded to within a short period of time may seem to have greater force in the wider world which reads the media.
Yes, and on that very point, we know that the inquiry will push on with its task, and what happens in the media is not what is going to happen in the report or in the evidence. But in my respectful submission, to air an allegation that is not contradicted, in public, reported, tweeted, live streamed on the internet for watching at later stages, goes against fairness if all the criticised person can do is provide a written statement and it gets posted online. These are criticisms of a doctor's professionalism, and I don't wish to...
So, would it be the case that a written criticism would be answered in writing? That would be entirely fair, but an oral criticism could not be?
Well, to deal with, if it's written, if it's going to be written down, it must be answered. We say that the doctor should have the choice to respond orally to those criticisms, whether or not they're written or simply verbal. At the moment, as matters stand, the criticisms have been through the form of the statements and through this medium from the witness box. We say that doctors should have the opportunity to respond in both ways. Because a written criticism is posted online, it's possibly commented upon, reported, tweeted, discussed, and that can be dispelled, that criticism may be dispelled by the context given by the doctor from the witness box. So we say whether or not the criticism is verbal or written down, the doctor should have the chance to reply to those criticisms verbally and orally before the court. Because the written criticisms the statements that I've had sight of are going to be published, they're going to be conveyed through the witness box. I must say that what has happened has been terrible, and everyone should have the right to have their story told. So it's not the infected and affected alone. They are an incredibly important part of this inquiry. We must also, as you said, sir, at the very outset of your opening, put people first. The doctors are still people. They still have stories to put forward. And it's that their voices must not be lost. They must not be... we can't have a situation where one voice is put front and centre and the loudest voice that we know because it's broadcast and reported. And the other side of a story, another person's story, is simply contained in a statement that is posted online. That there's an immediate objective objective imbalance in that system. And what my father, when he retired, embarked upon the hobby of repairing antique clocks, and that's not a plug, but when assessing these devices, he has to make sure the weight in the system is appropriate and that all the mechanisms are working properly and are fairly balanced. Because when you come to rely upon that clock, at the time you need to rely upon it, it's wrong unless you get it right from the very start. And what my submissions essentially are trying to do is highlight ways that we can adjust the weight in the system, the mechanisms in the system, to make sure that when the report is published, the infected, the affected, the medics, everyone involved can say, yes, it's the truth, yes, it's accurate, and it has been fairly reached. And those are why I'm making these submissions. And I hope that has answered some of your questions, Sir Brian.
Thank you very much.
Obliged.
Before I ask you to respond, Mr. Richards, may I just ask any other legal representative if there is anyone who wishes to support the application which has been made to me. If so, I'll hear what they have to say now. Thank you. Ms. Richards.
So there appear to be three principal aspects to the complaints or concerns expressed by the Trust and the Board. The first is that criticisms of an individual clinician's are criticisms of that individual's employer, and that it is an artificial construct, that's the phrase used in my learned friend's written submissions, to separate individuals from organisations. The second is that individual clinicians have not been afforded sufficient time or provided with sufficient information to be able to respond. And the third is the suggestion that as a matter of fairness, all clinicians criticised must be invited to give oral evidence, and no individual infected or affected should be allowed by the inquiry to voice those criticisms without the same opportunity being afforded to the clinician and at the same stage of the inquiry's proceedings. So in my submission, each of these complaints is ill-founded for reasons which I will briefly outline and based upon some misconceptions about the nature of the inquiry process. Before I deal with each of them, I have two preliminary observations. The first is this. The inquiry is seeking to establish the truth of what happened to thousands of people infected by the NHS with HCV, HIV, and other viruses, many of whom have died or are seriously ill. And it has been made clear at the time the inquiry was first announced by the Prime Minister that there is an expectation that the National Health Service should cooperate fully with that process. The second preliminary observation is this, consistent with your commitment, sir, to put those infected and affected at the heart of the inquiry. The inquiry hearings have been carefully structured so as first to provide an opportunity for some of those thousands of individuals, infected or affected, to tell, in most cases for the very first time, their story, to set out their account of what they recall or what they believe was done to them or said to them or not said to them, and to explain the myriad ways in which infection or the death or illness of a loved one has impacted upon them. That's the first stage of the inquiry's oral hearings. But as has been made clear from the preliminary hearing onwards, sir, there will, of course, be a series of further hearings in which doctors, politicians, and others with relevant evidence to provide about what happened and why will be giving oral evidence. It will not, of course, be practicable or feasible or proportionate for every individual criticised, whether a civil servant, a doctor, a pharmaceutical company employee or another, to be called to give oral evidence. Just as it is not practical or feasible for every one of the thousands of people infected or affected to be called to give oral evidence. And that is a reflection of the unprecedented scale of what happened and the unprecedented scale of this inquiry and the breadth of its terms of reference. Nothing in the Inquiries Act, in the inquiry rules, or in the principles of fairness require that every witness in the course of a public inquiry who may have relevant evidence to give must be heard orally. Still less is there any requirement in the Act, rules, or principles of fairness that such evidence must be heard at the same time as any individuals voicing criticism.
It's rather the opposite, isn't it? The rules contemplate that an accusation may not have been put to a witness to a person complained about during the course of the proceedings.
So, precisely so, and I'll come on to deal with Rule 13 in a few minutes, but that's absolutely right. It is, of course, the case that the inquiry will want to hear orally from a number of doctors involved in relevant decision-making. It is highly likely that the inquiry will want to hear orally from a number of the leading haemophilia centre directors, and it's highly likely that Dr. Mayne will be one of the witnesses who, in due course, the inquiry will want to hear from orally. Turning, sir, to the three elements I've sought to isolate of the trusts and boards' concerns. The first, that criticisms of the clinician are criticisms of the employer. So we do not accept or consider that to be correct. These are not civil proceedings. We are not concerned here with issues of vicarious liability. This is an inquisitorial process, in the course of which criticisms are voiced of named professionals. And where the inquiry identifies that there are professionals who should be notified of that criticism, it is for the purpose of affording that individual the opportunity to respond to what is said about them. There may, of course, be occasions where criticisms are directed fundamentally at the organisation or the trust, for example, the adoption of a policy, and in those circumstances, the notification of criticism may be directed to the organisation. But the clinician and the trust or other health body with whom they worked, for whom they worked in the past, are not synonymous. And there is, in my submission, nothing artificial about treating criticised clinicians as individuals. As to the allegation that notifying the clinician as an individual somehow has the effect of isolating the witness, that again, in my respectful submission, is incorrect. At the time the Rule 9 notification letters go to clinicians who are the subject of criticism in individual witness statements, it is made clear to them that they may seek independent legal advice and support. And it's entirely open to that clinician to go to their former employer or to a professional defence organisation or to another. But the process adopted by the inquiry regards it as a matter for the individual clinician as to whether to seek support, legal support, from their former or present employer or defence organisation. Some clinicians may prefer not to make contact with their former employer. The critical point is that is their decision. And our experience thus far has been some clinicians have chosen to make contact with former employers, others have turned to professional defence organisations, and others have simply chosen to engage directly with the inquiry on their own terms and without legal assistance. To the extent that it's suggested that the inquiry puts some impediment in the way of clinicians seeking legal support or advice, therefore that is incorrect. As I say, sir, the Rule 9 notification letter makes clear to clinicians that they can do so. And the general restriction order which you have made, sir, and which is publicly available on the inquirer's website, expressly provides that those who are in receipt of such notification of criticisms may seek legal advice and may disclose what they've been provided to their legal advisors for the purpose of obtaining advice and assistance. It's also been made clear to the trust in relation to the present context that if it wishes to circulate general information to current or past employees about its general willingness to provide legal support, it can do so. The particular issue that's arisen in the present context has arisen not by virtue of the Trust's role in these proceedings as an employer or former employer of individual clinicians, but because the Trust and the Board happen to be core participants in the inquiry. And in that capacity, they have received copies of witness statements that ordinarily a Trust or other NHS organisation would not receive. And they are bound, as all core participants are bound, for obvious reasons by confidentiality undertakings. So it's for that reason and that reason alone that the Trust cannot go to an individual clinician and say, we've seen the statement of Mr. X, we know you're criticised, let's talk about it. But nothing, I repeat, nothing prevents the clinician from going to their former employer or anyone else and seeking legal support and assistance. So the second point then, the complaint about insufficient time and insufficient information. Now we accept, sir, that clinicians have been asked to respond within a relatively short period of time. And that's simply a feature of the volume of material that's available, the timing of decisions to call particular oral witnesses, and the need then to notify clinicians of relevant criticisms. Ordinarily, a person criticised will be asked to provide a response within 21 days. Asked, not required, not ordered. And that's because ideally that means the clinician's response will be available when the witness making the criticism gives their evidence. Occasionally, the period of time has been less, and that's been a feature largely either of last-minute information being disclosed or last-minute changes for good practical reasons to witness schedules. But none of that is a deadline, sir. Clinicians may and have chosen to respond after the witness has given evidence. A clinician may well perfectly reasonably say that they cannot respond prior to the witness giving their evidence. And if that's the case, then they are afforded that further time that they ask for. As for the complaint about clinicians being given insufficient information to respond, the clinician will be provided with a copy of the witness statement and any relevant exhibits, because that is the material generally that the inquiry has. Insofar as the complaint is about the clinician not being able to access medical records or other documents that may be in the possession of the Trust, that is for a fundamental reason, that patient records are the patient's records, and there is a matter of individual patient consent to the disclosure of those records. The records are not the records of the Trust or the clinician to share amongst each other. And so where clinicians have come to the inquiry said, well, actually, I can't remember or I need to see the patient's records because you've asked me about events 20 or 30 years ago, could you please obtain the patient's notes for me? The inquiry has done precisely that, but it has done so through the correct and appropriate route, which is to ask the patient for their consent for those records to be disclosed. And so where the clinician wants to review the records, they will be afforded the time to do so. So that brings me to the third and most fundamental point. It appears to be the Trust's and Board's submission that you, sir, should not allow infected or affected individuals giving oral evidence to voice in the course of their evidence any of the criticisms set out in their witness statements. In other words, that when any of the witnesses who gave evidence today or who are scheduled to give evidence in the course of the week come to that point in their evidence when they're talking about their diagnosis or their testing or what they were or were not told, you, sir, should not allow them to give that evidence. They should only be permitted to give a partial or incomplete account, and that witness, and many of the witnesses, as it must be apparent, are in poor health or are giving distressing evidence about the death of a relative, that witness should then be recalled at some point in the future, with the clinician's response then being put to the witness and the clinician then being given the opportunity to give oral evidence to respond. At the risk of stating the obvious, that would cause very significant delays to the inquiry's processes. It's not a course which any other health body outside of Northern Ireland has asked the inquiry to take. The suggestion in my submission that a public inquiry committed to transparency and openness, whose terms of reference include allegations of cover-up or lack of candour, that public inquiry should prevent witnesses from giving relevant evidence and must recall them at a later stage, is untenable. It's inconsistent with the inquisitorial nature of inquiry proceedings. I note that no authority has been cited by my learned friend in support of the argument that this is the only fair way for the inquiry to proceed. And it's not a requirement under the Act or the rules. And so, returning to the point that you raised with me a few minutes ago, what the rules require is the process set out in Rule 13 under the heading Warning Letters. And Rule 13.1 provides that the Chair may send, not must, may send a warning letter to any person he considers may be or has been subject to criticism or about whom criticism may be inferred from evidence that's been given. And then, so it provides in Rule 13.3 that you must not include any explicit or significant criticism of a person in a report unless such a warning letter has been given and the person's been given a reasonable opportunity to respond to the warning letter. 2 points arise. Nothing in Rule 13 suggests that any person criticised must be called to give oral evidence. But secondly, and in any event, we're not even at the Rule 13 process yet. What the inquiry is currently doing through its criticism notification process is something additional to the requirements in the rules. In other words, we're doing more than the rules say we must do. There will, of course, be compliance with Rule 13 at a later stage, and our statement of approach on warning letters has made that clear. So, my learned friend's submissions were somewhat dismissive of the way in which the inquiry might use the material that's provided by clinicians, posted on a website. It suggested that's not good enough. Well, that's not an accurate reflection of the way in which evidence that is received from clinicians, or indeed from anybody else, is treated by the inquiry. Any statement received from a clinician will, after suitable processes of looking at issues of anonymity or redaction have been undertaken, be disclosed to core participants. It will be put into the public domain, and there as a public record of the clinician's or other person's response to the criticisms. But perhaps most fundamentally, it becomes part of the evidence and material upon which you, sir, in due course, will base your findings and recommendations. And so that process, combined with any subsequent compliance with Rule 13, amply fulfills, in my submission, the requirements of fairness. So there are just 2 final brief points, if I may. Firstly, although my learned friend did not develop these in this point in his oral argument, his written submissions suggest that in some unspecified way, his clients have been misled by the inquiry team. As a matter of record, I should say that is not, as far as I have been able to discern thus far, although few details have been provided, correct. And so I should put that there as a matter of record. Secondly, and finally, I have been asked by some of those who represent a number of the witnesses giving evidence this week to point out that where witnesses, for example, today have seen material only for the first time today, that has been in some instances because the Trust only found and disclosed some hundreds or thousands of pages of medical records in the last few days.
Well, last Thursday, was it?
I understand that to be the case. Certainly, we received them only, and those representing a number of the witnesses received them only either on Friday or over the course of the weekend, because of the practicalities of having them copied and so on. I have been asked, and I pass this on without making any comment because I've not had the opportunity, sir, on your behalf to investigate it. But I'm told that there have been real problems in this jurisdiction for individuals getting hold of their medical records. And obviously that does not assist either the witness giving their evidence or indeed the provision of timely information to any clinician who may wish to respond. So, unless I can assist further, that was all I wish to say in response.
No, thank you very much. Mr. Robinson.
Right, sir. If I can address the point about the isolation of doctors. There was a teleconference on Monday the 13th of May, and your team was expressly asked that if the doctors that were subject to criticism could talk to the trust about those issues, and we were expressly told no. That prompted an email from the DLS on the 13th of May, highlighting most of what I've said in my submissions, seeking the ability to contact doctors, dispelling with this artificial construct of separating out doctors. So we have been told expressly that those doctors could not speak to the trust. What my learned friend has opened is the current position as of last Wednesday, when we received correspondence back saying that a doctor could speak to the trust. So up until less than a week before the oral hearings, the doctors were not permitted to speak to the trust. Now, on the issue of access to documents and records, we had an 80-plus-year-old witness have to provide a statement because she wanted to have a statement in before the oral hearing started. She had to do that in relation to the care of 10 individuals, covering treatment from 1970 to the 1990s, in the absence of their notes and records, and also told she couldn't speak to the trust. How that is fair on any level is, I'm lost for words as to how that can possibly be fair to that witness. And not only fair to that witness, but also fair to the people that she was responding to. And it goes nowhere to securing the best evidence for this inquiry. Now, as for, I said in my opening comments that I wasn't going to explore some of the points I made in my submission so I can work collaboratively with your team. But I invite you, sir, to look at an email from your inquiry team on the 3rd of May, shortly after 5 p.m, from the individual I named in my submission. And it indicates that all the doctors, all the clinicians, apart from Dr. Main, have been written to about all criticisms. And we're also told that on Monday, the 13th of May, that information was incorrect. Now we have...
Sorry, what's incorrect about it? The
Because
email which I asked for a copy of the
Yes.
emails in order to consider it in the light
Yes.
of your submissions. And the email to which you're referring, the 3rd of May, is written, I think, to you as one of the, written to your email.
Yes.
It says the clinicians that you referred to other than Dr. Main have all been written to in respect of any criticisms.
Yes.
Now, is that what you're taking objection to?
No. We were... On the morning of the 3rd of May, that was the day we travelled to London, we met with your team. And we said, look, we've made contact with Dr. Main. We're trying to get her statement before the oral hearings. And we said, now, we've identified other doctors in the statements that have been subject to criticisms. We volunteered to contact them, bearing in mind the context of the hypernatremia inquiry and the criticisms about not contacting doctors. So we volunteered to contact the doctors. And the initial response from your team was, that would be helpful. That was 9 a.m. meeting in London. We received that email shortly after 5 on the Friday, the same day, moving completely away, or indicating that the other doctors had been written to, but also saying that we couldn't reach out to them. Now, we were also told on the 13th of May at the teleconference that all doctors had been written to. But we've learned since that that's incorrect. Doctors are being notified within days of this hearing. Now, I didn't want to air that because I'm trying my best to assist this inquiry get to its goal. But when my learned friend makes such criticisms, I have to answer them. Now, that's the point about the communications and what the trust has been trying to do. And I note the insinuation that the trust is in some way trying to stop the infected and affected give evidence. That is the furthest from what I said. What my submissions have been, and I want this clear from the record, for the record, is that it's to enable the parking of any criticisms so they can be dealt with fairly. And it doesn't cause delay in a process if everyone has proper notice of the criticisms and a proper opportunity to respond. Now, you have my submissions, sir. I'm not going to repeat them. We are here to assist this inquiry in the best way we can so that the infected and affected and all other parties get to the truth. So unless there's anything further.
No, thank you very much. My apologies to those of you who want to stay but are troubled by any transport arrangements. What I shall do, because of the need to have this issue resolved here and now, certainly I shan't regard it as at all discourteous if in the course of my making a ruling anyone chooses to get up and go. I certainly shan't regard it as a comment on what I'm saying, whatever it may be. I have an application made to me by the Belfast Health and Social Care Trust and Health and Social Care Board to alter the approach which the inquiry is taking in future when it comes to the taking of evidence from those infected and affected in relation in particular to any criticisms which that evidence may contain in respect of doctors or clinicians, putting the word doctor more generally. The legal framework. The inquiry is a statutory inquiry. Section 17 of the Inquiries Act 2005, headed Evidence and Procedure, provides as follows. 1. Subject to any provision of this Act or of rules under Section 41, the procedure and conduct of an inquiry are to be such as the chairman of the inquiry may direct. 3. In making any decision as to the procedure or conduct of an inquiry, the chairman must act with fairness and with regard also to the need to avoid any unnecessary cost, whether to public funds or to witnesses or others. In the inquiry rules, referred to in Section 17, in Rule 13, a procedure is made expressly in relation to criticism. Because the draftsman of the statute had in mind that the inquiry had to be fair, I take it that Parliament, in making these rules, thought this was the requirement of fairness which the Act provided. It does not prevent any procedure which may be more fair. Rule 13, 1. The chairman may send a warning letter to any person, A, he considers maybe, ... subject to criticism in the inquiry proceedings. Subsection 2, the recipient of a warning letter may disclose it to his recognised legal representative. 3, the inquiry panel must not include any explicit or significant criticism of a person in the report or any interim report unless A, the chairman has sent that person a warning letter, and B, the person has been given a reasonable opportunity to respond to the warning letter. Rule 14 goes on in matters which are potentially material, but I won't take time to set it out now. What I take from the combination of Section 17 and Rule 13 is this, that the procedure must be fair, that fairness involves giving someone who may be subject to criticism, if the chairman thinks it desirable, as an option, the word is may, the right to respond at the time of the inquiry itself, but certainly must be in a position to respond to any report. In other words, the Act and rules do not necessarily envisage that a person who is criticised by a witness has a right to respond there and then, whether in writing or orally, providing that, overall, they have a right to answer any significant criticisms made. Significant, that is, in the eyes of the inquiry. So much for the framework. The argument. Mr. Robinson, in a careful, measured address, emphasising the desire of the Belfast Health and Social Care Trust to help the inquiry, come to a report which is truthful, accurate, and unimpeachable, argues that there is currently an impediment to that caused by a problem where a doctor is criticised and does not have enough time to respond in detail before the criticism is voiced in public. He argues that it is not simply a question of a clinician being criticised, but the employer of that clinician, because, he argues, the trust and the clinician are as one, and it is artificial to draw a separating line between them. He proposes, because of the difficulties which this, he submits, cause in practice, that there is a desirability in fairness, and indeed his submission must be it is only fair, that a clinician be put in a position to respond immediately a criticism is voiced. The procedures which the inquiry has adopted, as Ms. Richards submits to me, go further than those required by Section 17 and Rule 13. In that, they provide for any significant criticism or anything which might be seen by a reader or listener as significant criticism to be notified in advance to the person who is subject of that criticism. They may, if they wish, but they don't have to, answer it. The timing currently for that is 21 days before the evidence is likely to be given orally. The reason for that is to give a reasonable opportunity for the doctor not to respond to the criticism. They have that right throughout the inquiry proceedings until it ends. But to respond at a time when, if they do, their response will then be published at the same time as the witness making the criticism has their statement published. So that as a matter of procedure, anyone reading both the witness statement and the clinician's statement in response will see both sides of the picture there and then. And as a matter of fairness, I expect Miss Richards to do as she has done and raise the matters of significant response with a witness when they give evidence, as you heard her do this morning. In that way, it is thought the danger that the media will report or people will read the evidence as creating an allegation which, because of the mere fact it has been made as an allegation, is treated as though it were fact, is minimized. There is always a danger, I think, in reality, that if an allegation is made, it may be treated as having more weight than it should have. One does not need to give examples. It is, however, in the nature of all forms of judicial process, where there are contested trials, for instance, that one side will set out its allegations first, and in a trial, for instance, lasting a number of weeks, whether it is criminal or civil, those allegations will remain unanswered, though they may be questioned, until other evidence is given at a later stage, whether that evidence is given on paper through documents or whether it is given orally. This is not contested proceedings in the nature of a criminal trial or a civil trial. An inquiry such as this has no power to find anyone guilty of a crime, nor to hold any person liable for any particular sum of damages. It may make findings which may lead to those conclusions, but that is a matter for others and not for the inquiry. So the context is different. We have no, I am not here sitting as an umpire in respect of two rival cases. I am conducting an inquiry, trying to find out what happened, taking all shades of opinion, listening to all accusations, listening to all counter comments, and forming, I hope, a fair and balanced view at the end of the day. And I think, as Mr. Robinson implicitly recognized in his submissions, the end product of the inquiry is a report. It is that report, at the time of that report, that those who may be subject to criticism must have had a proper opportunity to answer it. That is the system of fairness which, as I see it, the law requires, and which this inquiry is determined to ensure will happen. The individual concerns which give rise to Mr. Robinson's submissions on behalf of his clients contain, as Ms. Richards rightly identifies, in my view, three strands. The first, the criticisms of an individual are criticisms of the employer. Therefore, where the employer knows of the criticisms, it ought to be able to talk to the clinician without the clinician having asked the employer to do so. That secondly, that there is no time or sufficient information to respond within the periods which the inquiry provides. And thirdly, that all clinicians criticised must be invited to give oral evidence. As to those, I consider that the answers which Ms. Richards has given are, to my mind, answers of greater force than those of the submissions made by Mr. Robinson in the counter. First, I do not consider that in the context of an inquiry, a criticism of an individual is necessarily a criticism of the employing trust. It may be, because it may give rise to the belief that a trust has a particular policy or practice, which nowadays one would criticize even if then one didn't. But the individual actions of an individual doctor are a matter for the individual. And if it is the individual whom a witness, one of the infected, or one of those who have been infected or are affected, wishes to make, then it is that doctor who is criticized and not directly the trust. The fact that in civil proceedings the trust might be held liable to pay damages for any failure which amounted to negligence on the part of the doctor is beside the point. I do not accept that it is right to give the choice of whether the doctor speaks to the trust or the trust to the doctor about criticism of the doctor be given to the trust. It is not a matter for the employer to decide whether to discuss matters with the employee. The criticism is made of the employee, and the employee should have that choice. I consider that the employee should have a free choice whether they discuss that matter with their legal advisors, just as anyone who is criticized in any proceedings may choose to have lawyers or not. I consider that it is a matter for the person criticized to decide whether they wish to raise it with their employer or to take advice from professional insurers or professional associations. My reading, I should add, of the rules and of the general restriction order which I have made are that they may discuss matters with their professional advisors. And the word professional is wide enough, I think, to encompass more than simply lawyers. It will include the professional advice services of a trust, should it have one. But that is provided, of course, that advice service will keep matters confidential, because that is what the individual is entitled to, and the person making the criticism is entitled to the confidentiality of their name. The reason for confidentiality is that in many cases the identity of a witness is not recorded on the face of the statement because a witness may seek anonymity. Where that witness makes a criticism of a doctor, it would be unfair to invite the doctor to respond against an anonymous accuser. No one would wish to be in that position. And so where a criticism is made of a doctor by an individual, in general, the doctor will be told of the identity of that individual, but he must, of course, keep it confidential because the witness is anonymous. And that's why it must go no further than the confidentiality undertakings which are made in general by lawyers and other professional advisors who have that relationship with the person involved. As to the second criticism, no time or sufficient information to respond, this is a large and difficult inquiry. Time is not our friend. People are dying, as one witness this morning reminded us. It is my commitment, and it is necessary, that this inquiry should take no more time than reasonable thoroughness permits. It seems to me that any time limits imposed have to be seen in that context. and in the difficulties of managing what is, I think, the largest public inquiry which this kingdom has ever seen. The time that a person has to respond to criticism is until the end of the inquiry. There's plenty of time. The immediate response is asked for, in terms of the inquiry procedure, at least 21 days before the witness is called to give evidence. There will be exceptions to that where, as Ms. Richards has pointed out, there are late changes to the witness order, where necessarily things happen as a matter of urgency, or where, as happened last week, documents are suddenly discovered which give rise to new issues. That is, to some extent, inevitable, but the general rule will be, in my view, and should be, that as much time be given as possible in advance of publication of a criticism, and to allow the person criticised to have their response published at the same time, if that is what they choose. It's difficult for some. It is difficult for those who have a number of criticisms to respond to. I have little doubt about that, and they can be assured that I will take that into account at the end of the day. I shall not hold it against someone who has had limited time to respond that they did not respond immediately or in time. It would be unfair of me, in general terms, to do so. But as a matter of process, there's nothing inherently unfair in asking someone to respond by a particular time, or, as they may well do, indicate that they haven't got enough time, and that, of course, will then be taken into account and mentioned. I have to say, in passing, that the inquiry would wish to pay a tribute to Dr. Main's efforts, despite her difficulties with, I shan't go into, to provide a response in time for the hearings this week on what would have been for her relatively short notice, but the fact is she did it. Thirdly, the submission that all clinicians criticised must be invited to give oral evidence. I agree entirely with what Ms. Richards has said about that. There is nothing in the rules which require it. The inquiry here will most probably hear from anyone who you, as members of the public, might expect it to hear from, subject, of course, to their states of health. But I can't say at this stage precisely who will be called or when. If and when clinicians are called who have been criticised by a number of witnesses, it will be a matter for them, the extent to which they wish to give evidence about those criticisms in answer, or whether they wish to leave it simply as they have written in their written responses. But I do not think that fairness or the truthfulness of the overall report, or the accuracy of the overall report, would be affected by the process which the inquiry has adopted. The inquiry is determined to listen to the criticisms as and when they are made. It would be artificial to have a witness come who wishes to make criticisms, to have to come back to make those criticisms later, to give the clinician more time in order to respond to them. It would be artificial to have a clinician, it would be impractical to have a clinician respond immediately after each criticism as at one stage seemed to me to be the submission which Mr. Robinson was making to me. It is practical that doctors who may well be criticised in any report, though one can't say without listening, are able to give evidence in one go, carefully, after due consideration later in the process. It follows that I do not think that the inquiry process at this stage needs to be adapted or altered. I am gratified in reaching this ruling that no other council or core participant other than the Belfast Health and Social Care Trust and Health and Social Care Board has invited me to make this change, or indeed has said that they support it. It seems to me that the process, therefore, will remain as it is. As to the matters which were voiced by Mr. Robinson in his response, may I make it clear that my view of the procedure, and it is a matter for me under Rule Section 17, is that a clinician who is criticised may, if they wish, share that criticism with their professional advisors. And as I've said, I take a broad view of that, providing that there are sufficient and proper assurances that those professional advisors will respect the confidentiality which the accuser may enjoy. And may I also say that as a matter of general process, as much advance notice as is reasonable should be given in each case, and it will not simply be a matter of 21 days as an absolute time, maybe more in many cases, though as I have indicated, there are occasional moments when the timing will be rather less. Now, Mr. Robinson, it follows that I am grateful for but reject the application that you've made. Is there any matter which I have not covered which you would submit I should? Thank you very much. Well, now that concludes the formal proceedings for today. What do we have tomorrow, Ms. Richards?
So tomorrow we are hearing from 5 witnesses. We are hearing first of all from Simon Hamilton, then from Danielle Mullen. We then have 3 anonymous witnesses, Mr. F, and then 2 witnesses, Mrs. G and Mrs. H, who will be giving evidence together from the witness stand. And I understand that the timetable provides for a 10 o'clock start tomorrow.
10 o'clock tomorrow.